Thank you, of course, to all the assistants that are here with us at University Carlos III. We're going to start with this fourth panel, which follows the last one this morning. It's related to some strategic issues on topic before, during, and after armed conflicts. Participants on this panel are Professor Montserrat Abad Castellanos, she is Professor of Public International Law and International Relations in this university, and is one of the co-directors of this workshop, together with Thomas. And so I won't have to remind you with this kind of, that's just 5 minutes or 2 minutes. We are we are a little bit, well, out of time. So I'm going to do the presentations as quick as possible. On my left, we have Doug Weir, who is researcher on and has actively done advocacy on the polluting legacy and armed conflicts and military activities since 2005, and he's the director of the Conflict and Environmental Observatory. So thank you very much to be here with us. It's a pleasure to have you here at University Carlos III in Madrid. And finally, we have Professor Thomas Hansen, who is assistant professor at this university, University Carlos III of Madrid. Is associate professor here at the University Carlos III of Madrid, but also professor at Ulster University on transnational justice in the Transnational Justice Institute at that university, and together with Monse, co-organizer of this meeting, of this workshop. Thank you, three of us, the three of you, to be here with us, and in my case, thank you, both of you, to have invited me to chair this fourth panel. And now, Monse, yours is the floor.
Thank you, Felix. Well, my brief comments on this topic. Good afternoon again, everyone, and many thanks to all. My brief comments on this topic focus on Martens Amman clauses, intending to show that there still are under-researched aspects at the intersection between sectors of international law in such a way that strategic work could perhaps contribute to prevent further environmental crimes. Dramatic images of destroying nature, including human beings and non-human elements, are being or have been usual in most current or recent conflicts, like Ukraine, Syria, Iraq, to name just a few. Despite scorched earth tactics having a hallmark of many wars since ancient times, we should aspire at this stage of evolution to have a civilized treatment of victims of war, including the environment. However, the point of departure is especially challenging and perverse, since everything what is most protected from the legal perspective often becomes a deliberate target on the ground. On this basis, I have built my remarks on a list of 4 points connected with these two clauses, the Martens and Amman clauses. First, 4 are intertwined, having environmental content. Both invoke established custom, principles of humanity, and the dictates of public conscience regarding the protection of the environment. Both still entail uncertainties and lead to discrepancies, but have solid customary roots, and both can mutually reinforce each other and be leveraged to drive opportunities and prompt new tools. The Martens Clause took its name in this evolution until becoming environmental, took its name from the Russian diplomat and international lawyer Martens, who participated in the first Peace Hague Conference in 1899. This clause was established for the first time in the preamble of the Second Hague Convention in relation to populations and belligerents, and it was proposed to break a diplomatic deadlock in the negotiations between smaller and great powers. This Marten clause was reaffirmed later in subsequent key international humanitarian law treaties, among others the convention adopted in the Second Hague Peace Conference, in the Geneva Conventions, in the 1977 additional protocols, and also by the ICERCs in its guidelines regarding the protection of natural environment in armed conflict, adopted in 1994, revised in 2020, and endorsed by the General Assembly. Later, it was reformulated by the IUCN in Amman in 2000, as we are going to see, and finally, the International Law Commission's draft principles devotes its principle number 12 to this content, extending the language used in the first additional protocol. Well, both clauses are intertwined. You can see here the bold Martens clause on the left, included in the ILC's draft principles, replacing civilians and combatants by the environment. In cases not covered, the environment remains under the protection and authority of the principles of international law, derived from established custom, from the principles of humanity, and from the dictates of public conscience. Well, the IUCN adopted the Amman Clause in 2000, and you can see here the main differences. It was drafted by Dinah Shelton and Alexander Keys, urging all United Nations member states to endorse a policy that respects a minimum standard for environmental protection in the absence of relevant international conventional law or regulation. And the main key differences are highlighted. The Amman Clause refers explicitly to the biosphere and all its constituent elements and processes. It refers to the future generations specifically, and it is also applicable in peacetime, not only in wartime. Both clauses still entail uncertainties and lead to discrepancies, but have solid customary roots. Regarding the content of the principles of humanity and the dictates of public conscience, well, there are still doubts about the connection with natural law and with the world public opinion. And regarding the scope, well, it is also uncertain if these dictates have to be necessarily universal, or could there be differences considering regional or local traditions. There are discrepancies. In particular, there are three main lines of thought. According to maximalist view, it could be considered that the Martens Clause as such is bringing new sources of international law. But in the middle of the road, it is usually thought that it is only applicable when interpreting the appropriate rules. And according to a minimalist view, the main function would be just preserving the pre-existing customary law. In any case, it has solid customary roots, as the International Court of Justice acknowledged, stating its continuing existence and applicability in the advisory opinion regarding the threat or use of nuclear weapons. And this, it could be said that these customary roots may be even growing. It is reasonable to think this way, on the one hand, because of the recent extension to the protection of the environment and the rise of environmental law, and on the other hand, thanks to the contribution of PERAC, which could be influential to push further the international agenda relating to these aspects. Both clauses can mutually reinforce each other and be leveraged to drive opportunities and prompt new tools. In fact, international law can be a transformative power in this field. nature and conflict. Martens and Mann clauses have a potential yet to be developed, which is vital to achieve for strengthening the prevention of further environmental crimes. How? Filling the gaps in positive law through the principles of humanity and the dictates of public conscience, identifying and promoting clear and operational rules based on them, in particular for non-international armed conflicts, due to the silence of the IHL's conventional norms on the protection of the environment in this kind of wars. Also building alliances between like-minded states, the ICRC, strategic NGOs, and civil society, to work together on the identification of clear and operational rules that derive from the principles of humanity and the dictates of public conscience. And finally, disseminating rules better and reaching key actors and battlefields. It is necessary to go beyond institutional fora and multiply their impact on the key stakeholders on the ground. In fact, as the International Committee of the Red Cross made clear in its 2019 resolution, bringing international humanitarian law home, IHL must be better disseminated. However, this resolution neither mentions environment nor logically goes beyond IHL. Therefore, there could be room here to bring nature into the scene and improve the intersection between IHL, environmental law, and human rights law. Therefore, the conclusion about the question that I have posed at the beginning is not necessarily pessimistic. In fact, I think that there is room for strategic work and cooperation in this area in order to make a more effective appeal than it has been so far. Thank you very much.
Thank you, Montse, and also thank you for being so quick in your explanation. And now, Doc Weir, the floor is yours.
Good afternoon, everybody. Thank you, Felix, and particular thanks to Montse and Thomas, the sponsors and the previous contributors, and the delightful surprise at lunchtime, which I hope you'll enjoy later on. I'd like to speak quite briefly on the ILC's two principles on remnants of war, so principles 26 and 27. We launched CEOBS, Conflict and Environment Observatory, in 2018, and it built on a 6-year research project focused on conflict and military pollution. And what we do at CEOBS, conflict monitoring, research and advocacy, is very much informed by that experience. So the physical, chemical and explosive remnants of armed conflicts and military activities can create lasting threats to communities and ecosystems. They pose immediate and long-term risks to human health and livelihoods and undermine the viability of the natural resources upon which the human population depends. One important point about the ILC's approach is that Principles 26 and 27 help to reconnect the discourse on war remnants to earlier, more holistic framings. So during the 1970s, actors such as UN Environment Programme, they talked about the material remnants of war, and this might be anything from barbed wire to landmines to residues of chemical defoliants. And it was the initiatives on anti-personnel landmines, explosive remnants of war, and later cluster munitions that reframed war remnants as an almost wholly humanitarian rather than environmental problem. The change was profound, and until recently, efforts to engage those dealing with the acute risks from explosive remnants of war on the acute or chronic risks from conflict pollution were always a struggle, even where mine clearance staff themselves might be at risk of exposure. We and others began to challenge this orthodoxy through the promotion of an advocacy and research framing on toxic remnants of war back in 2012. Our approach was based to some extent on our work on depleted uranium weapons, which again fell between the frames used in humanitarian disarmament processes. So for depleted uranium, it wasn't toxic enough to be a chemical weapon, not radioactive enough to be a radiological weapon, too unconventional to be a conventional weapon, and, well, the users didn't like to dwell on them being incendiary in nature when firing them against civilian objects. But the toxic remnants of war framing was not just about identifying particular pollutants or the practices that generate them. It was also focused on the commonality of response, environmental monitoring, assessment and remediation, and the difficulty in identifying and tracking patterns of harm, often mixed exposures and vulnerabilities, and slow onset multi-causal illnesses such as cancer or congenital birth defects. Generally speaking, the remnants and their harms were not being addressed, and where they were, it was usually as a result of military personnel being exposed and made ill rather than civilian population. Nevertheless, there was and remains no shortage of peacetime practice to go on, and in some cases we also had military risk reduction practice that could also be applied to the protection of civilians. So that's kind of the little background on conflict pollution, toxic remnants of war. So on to the principles themselves, and I'd just like to highlight a few important elements of the text. So starting on Principle 26 on remnants of war. So the first is a more expansive and holistic framing of toxic and hazardous remnants of war, as opposed to the narrower explosive remnants of war. And while the principle speaks of threats to the environment, the commentary observes that both remnants can harm people as well as ecosystems. It's probably worth pointing out that all the common energetic materials used in explosive weapons are toxic to some extent, be it TNT, RDX or HMX. So even these most basic bombs or grenades or landmines have toxic components which don't magically disperse or disappear when they explode. The second point relates to the actors involved, so it's parties to an armed conflict, and jurisdiction and control, whether de jure or de facto, reflecting the role that both state and non-state actors can play in addressing remnants. The third, the timing, as soon as possible, reflects the reality that clearance is typically undertaken both during and after conflicts. And finally, the obligation is without prejudice to existing obligations under disarmament law, of which there are many. So since the draft was published in 2016, a number of states have questioned or objected to elements of it. These objections tend to focus on whether the principle created a new obligation under Protocol 5 of the Convention on Certain Conventional Weapons, the customary status of that protocol. They complained that the term toxic remnants of war was not defined under international law, thanks to the International Law Commission in that regard, and they queried the term, or rather the extent of the obligation to seek to. Some of the states that objected included the US, France, Netherlands, Israel and the UK. So turning to Principle 27, unlike explosive remnants of war on land, obligations for monitoring or removing remnants of war at sea are far less developed. This is reflected in the brevity of the principle and its orientation towards two fairly simple ideas. The first, that remnants of war at sea should be addressed by both states and relevant international organisations. The second, that cooperation is the order of the day. A third important point is the Principle 27 extends the territorial scope of 26 to areas where jurisdiction can become complicated, the seas. As a special rapporteur observes, here states may have sovereignty, jurisdiction, both sovereignty and jurisdiction, or neither sovereignty nor jurisdiction. A final point is that because the legal obligations and practice are underdeveloped in this area, the principle was always intended as a contribution to a future conversation and not the final say on the matter. So Principle 27 elicited fewer responses than 26, as well as praise from affected states. Those who did speak generally questioned practical components of it. So, for example, given that dealing with marine remnants of war is costly and may create environmental risks while it's being done, should any decision to act first be informed by an environmental impact assessment, for example? And now it reflects what is the extent of the obligation that states are picking up with this. Turning to other questions of a practical nature, we can identify a number of barriers to implementation of the two principles. For 26, this might include the capacity of states, de facto authorities and others to act, given the technical and financial requirements for managing toxic remnants of war. The currently ad hoc nature of post-conflict environmental assistance is also problematic. And on a more specific level, the potential role of Mine Action and other organisations in identifying and responding to pollution risks is as yet underdeveloped. This includes tasks such as site identification and prioritisation. I'm happy to provide some observations on this later based on the current work in Ukraine. For Principle 27, again, there are systemic challenges around remnants at sea that will continue irrespective of the work of the ILC. These include disputes over liability, jurisdictional problems, technical constraints, and the linked issues of cost-benefit analyses and the environmental risks of intervention. So to conclude, Alongside climate change and biodiversity loss, pollution is one of the three fundamental environmental threats that we face. Conflicts generate pollution and create and sustain the conditions where pollution is more likely to occur and is less likely to be dealt with appropriately. Conflict, pollution and the toxic remnants of war have risen up the international agenda of late, and the ILC's work is a very positive contribution to that process. With greater attention should eventually come more expertise, capacity and resources to address the problem. But while the principles are probably a fairly modest step towards or forward for work on remnants of war generally, by taking a holistic approach that isn't exclusively anthropocentric, they speak and contribute to a general and very long overdue trend towards the rapprochement between humanitarian mine action and environmental protection. And I shall leave it there. Thank you.
Thank you. Thank you very much. As you see, we are gaining time to time. So now, Thomas, whenever you want, the floor is yours.
Yes, thank you, Felix. Thanks, everyone. So very briefly in this presentation, I will look at how transitional justice has dealt with environmental crimes, and sort of the argument is that historically it hasn't really done so to any large extent. And then I will follow up on that by looking at what could be the potential of transitional justice in that regard, and on that note also briefly discuss the relevance of the international law commission principles. So that's what I hope to do within the 10 minutes that we have granted ourselves for these presentations. So to understand why transitional justice has historically largely failed to look at environmental crimes, I think it's necessary to look at the origin and developments in the field. So transitional justice came about in the context of the Latin American transitions out of dictatorship and military rule, and later on the transitions in Central and Eastern Europe. And sort of the assumption of the early field, both as an academic field of inquiry, but also as a set of practices, was that the main goal of transitional justice was basically to bring about liberal transformation, so democratic consolidation, and also, of course, it was important for transitional justice to pay attention to the interest and needs of victims. It was very state-centric in the sense that it was understood that it was the state that would take the initiative to bring into play transitional justice, and it was the state that would implement transitional justice. Also closely linked to North American thinking in terms of the perceptions of the goals and the processes and what types of violations were those that were critical to transitional justice, and that was mainly violations of civil and political rights, and more specifically what we can call physical integrity violations, so torture and disappearances and all of that, but less so economic, social, and cultural rights, and certainly not at the point anything that had to do with the environment. So those contours of the early field, I think, have shaped to a large extent what happened in subsequent decades. That this neoliberal paradigm got closely associated with transitional justice, and only more recently, not so recent anymore, but for some time now, we've seen a critique of that, and there's been more attention to economic, social, and cultural rights, at least in transitional justice discourse. So it's argued, or it has been a quite common critique, if you will, that transitional justice is not paying enough attention to economic, social, and cultural rights violations, and there have been also, in some cases at least, some attention to that in the practice of transitional justice. Much less so, I would say, with respect to environmental crimes, that it remains in the periphery of transitional justice discourse, even though, as we shall see in just a few in a short while, then increasingly some scholars are calling for more attention now in transitional justice scholarship to environmental crimes, and also in both environmental crimes as a source of conflict, but also as something that should be addressed by transitional justice tools. And then, of course, transitional justice being quite closely connected to international criminal justice, of course, what has happened in that field in recent years, most notably with the ecocide proposal in 2021, we see more attention in that legal domain. So I think I would now jump to some of the arguments that have been made in transitional justice discourse more recently, why it's useful or why it's even needed for transitional justice to attend to environmental crimes. And this is sort of a little bit of cherry picking here. It's based on a fairly a review of what has been said in the scholarship on this topic, and as I mentioned before, we do increasingly see a number of scholars who are now, for different reasons, calling for transitional justice to pay attention to this. So it's saying some are speaking about greening transitional justice, which would also question the dominance of global north perspectives, incorporating the knowledges of the global south and indigenous communities for alternative understandings of violence, harm, and crime, scholars like Kelean and Dempster say. Incorporating greater environmental awareness into a from-below approach would involve centering responses to conflict in the lived experiences of people and their natural environment, set by Clark also quite recently. So in that sense, this below argument has been quite popular in transitional justice discourse in recent years, that transitional justice shouldn't be imposed from elites, but it should be sort of grow organically out of the communities most affected by violence. So in that sense, if those arguments could connect to attention to environmental crimes, that might be to the benefit of the possibility of actually paying attention to these crimes. Others speak about making survivors and environmental activists active agents in transitional justice, so a bit along the same way, basically correlating to this from below argument. Others again say that truth-seeking and legal accountability around natural resource crimes undercut impunity and help generate public discussion and raise awareness, which helps build civic trust, facilitate democratization, and contribute to reconciliation. So here we see also perhaps an attempt to link transitional justice dealing with environmental crimes to some of the more common objectives of transitional justice, common aims, if you will. So we've seen different arguments in the literature. Some now say that transitional justice should be used to address natural disasters, specifically in situations where governments or states, they fail to put in place adequate responses to these kind of disasters. So of course, transitional justice cannot deal with the earthquake itself. You cannot really, prosecute an earthquake or subject an earthquake to a truth commission, but more so the agents, the actors who maybe put in place inadequate responses to that. So a lot of what has been said has focused around criminal prosecutions, and that perhaps goes together with what we talked about before, namely the intersections between transitional justice and international criminal justice, and the ecocide, the recent ecocide proposal. However, there's also been some debate about how truth commissions could be used in this regard, less so it seems from my review of the literature concerning reparations, at least to date. So let's move on very briefly, looking at some examples here of how transitional justice has in practice addressed environmental crimes. The Truth Commission in Kenya found that grievances relating to land were the most dominant source of the conflict, the post-election violence specifically, but also more historically violent conflict in the country. In East Timor, the Truth Commission also, or in that case, addressed contamination of water sources. A peace agreement between Peru and Ecuador that settled a long-standing violent border dispute touched on the inclusion of an environmental management structure for a shared rainforest. And in Colombia, the trials that have been put in place to deal with the civil war in that country have recognized the territories of certain communities as victims of the conflict. So that's quite interesting, really. And also we see some attempts in Peru. And now I see that I'm running pretty close to my time. So before Felix is going to give me the sign, I will just very briefly touch on how the ICEL draft principles could connect to what we talk about here. So principle 22 concerning peace processes seems quite relevant in that regard, that the parties to an armed conflict should, as part of the peace process, include where appropriate in peace agreements address matters relating to the restoration and protection of the environment damaged as a result of the conflict. And of course, since transitional justice measures are nowadays quite often adopted in the context of peace agreements, this could be an argument invoked by activists and others who would like to see environmental crimes being addressed by transitional justice. So that could certainly prove a helpful tool in that regard. Principle 23 regarding sharing and granting access to information could be a relevant argument for facilitating the truth-seeking measures in transitional justice that they address environmental crimes. Principle 24 concerning post-armed conflict environmental assessments could be an argument for the UN and other funders of transitional justice to insist that environmental crimes are addressed. Principle 25 concerning relief and assistance again could be vital for making transitional justice reparations for them to include redress for environmental crimes. So there seems to certainly be a relevance of the draft principles to advocacy to include environmental crimes among the crimes that should be subject to transitional justice. So to conclude, transitional justice emerged in a context where the focus was on facilitating liberal transformation, and the types of crimes and abuses that were subject to transitional justice were predominantly civil and political rights, especially physical integrity violations. And the field and practice of transitional justice have since expanded significantly, both in terms of the types of transitions, so the types of contexts that are being subject to transitional justice, access and timing of justice responses. Yet environmental crimes to date remain in the margins of transitional justice discourse, though increasingly it's gaining attention in the field. And as we have seen, there are also now some examples from practice as to how transitional justice deal with those crimes. So thank you very much.
Thank you. Thank you, Thomas, and thank you, three of you, because your 10 minutes have been 10 minutes to one of you. So thank you very much. And so this panel and also the previous panel are open for your questions, both here or online, if you prefer. So, go ahead. Any question? Any questions for both this panel or the previous panel? We hadn't time to open it to your opinions, observations. Yes, go ahead.
Do I need to wait for the...
Yes.
Yeah, the
Micro.
is here.
Is this on? Sorry. Is it?
Now you have to press, I think.
Ah, I think that's
No,
right.
no,
Okay. It's mostly for Thomas in terms of, well, it might be a mean question, bearing in mind you didn't have time to cover it in so much detail. But thinking about the ecocide proposal at the International Criminal Court, do you think that is a proposal that's going to be accepted, or do you have any critique of it?
I just answer right away.
Yes.
I mean, I think it's ambitious, and things have to start somewhere when we speak legal change and legal transformation. To be honest, I think it's quite unlikely that it will be adopted anytime soon, if ever. I doubt that state parties would agree to it, despite the attention that it has gained in recent times. Perhaps what could happen is that it initiates a debate that at some point lead to some form of change of the Rome Statute. In that regard, could perhaps be an amendment of existing articles to make it easier. As the way the Rome Statute looks now, it's incredibly difficult to prosecute environmental crimes, as you know, Karen. So I think it's a positive development that it has been tabled, but I see serious practical and political obstacles for it to actually be implemented. That's my brief take on it.
Yeah, of course. Yes, go ahead.
Sorry, can I ask a question from Doug? Just to see if there's any examples from previous conflicts, thinking particularly about Ukraine maybe, in terms of toxic remnants, just to throw it to you, if that's all right.
As examples of ecocide.
Oh, sorry, no, in terms of your paper, in terms of toxic remnants of war and any examples that that you can just tell us about briefly that we should be looking out for?
I think the whole conflict is an interesting example in that there is better documentation of environmental harm in Ukraine than any other conflict in history. I think there is the question of, obviously there's a lot of potential and scope for environmental damage, and particularly conflict pollution, because of the intensity of industry and energy infrastructure across Ukraine and the intensity of the conflict. I think what will be very interesting to see will be, does that knowledge and that degree of harm translate into meaningful action to address conflict pollution during recovery? And I think that's a very open question at the moment, because, as I said in the presentation, these responses are ad hoc. Every conflict is different. There's not necessarily sufficient capacity there. There's not necessarily going to be enough political attention on these components of environmental harm to make sure that they're remedied, because remedying these problems is expensive and time consuming. And if it can't happen in Ukraine, where you have a very clear pattern of damage and a very high degree of documentation, it opens a question of where will we see it and what actually does have to be in place before conflict pollution is dealt with in a meaningful way in different conflicts.
Okay, I think we are running out of time, so we have to leave room to the sixth panel. So thank you very much, the three of you, and
Thanks to
let's
you.
go ahead with the seminar. Thank you.
Start the fifth panel, this very interesting workshop. This is the last, first of all, good evening, everybody here present and also in the cyberspace. Yes, I think it's the last panel, normal panel. However, we have a sixth panel that is going to be the wrap-up of the whole workshop. And I think it's the last but not the least, because I think it's very interesting because we are going to focus on the implementation, on all the debates, all the studies, all these kind of discussions on the environmental protection in armed conflicts. And we will start with the first speaker that will be Ellen Obregon, that has been also acting in the third panel. Okay. Because she is one of the authors of the International Committee of the Red Cross Guidelines on the protection of the natural environment in armed conflict. That this document set out the rules and recommendations relating to the protection of the natural environment under international humanitarian law. It can be used, and I look at my two companions next to me, because it can be used as a reference tool for states in this subject. And well, for the people that has been incorporating later, Helen is legal advisor at the legal division of the International Committee of the Red Cross in Geneva, Switzerland, and also she has a master in law in international humanitarian rights for the Geneva Academy, and also a Bachelor of Science in Foreign Service from Georgetown University. And the second one is going to follow the protocol in the government, in the ministries in the government. It will be the Foreign Affairs in the Spanish government. It will be Santiago Ripoll at my right, that he is the head of the International Legal Department in the Ministry of Foreign Affairs. And he will speak about the government role from the Spanish perspective. And I will highlight some of the very, very extensive curriculum. His doctorate in law in 1990s. He was legal advisor at the Constitutional Court, and also is author of several works. But one book is related to the Constitutional Court and the fundamental rights. He is a very, very important expert. And due to the times that we are living now, I think it's interesting that he is member of the International Nuclear Law Association. He can, yes, say something about that. Okay, and the third one is going to be the Colonel Lázaro Albarracín. He is the head of the area of the environment and sustainability in the Ministry of Defense. And he is going to speak about the military doctrine, policies, principles, and normative framework in the NATO and EU's operations. And I won't highlight from his curriculum vitae is in 2017, when he was promoted to colonel, it was responsible for the support in the environmental questions for the military bases in the center of Spain, in the military center region. And also he was the defense military attaché in Washington in 2019, and he has a very, very extensive experience in multinational operations. He was in Croatia in 1997, he was in Kosovo in 2003, he was in Bosnia and Herzegovina in 2006, he was in Afghanistan in 2010, and he was in Kuwait and Iran in 2014 and 15.
Iraq,
Iraq. Yeah. Iran is a very, very dangerous place. Okay, Iraq also. But, well, thank you very much, the third, and Helen, the floor is yours.
Thank you very much, and sorry, I'm just trying to get this computer sorted. So, thank you very much. I think we've already all heard the impacts of war on the environment. I won't go over them again. You have some of the effects we see on the screen. But just to say that all of this today, of course, is enhanced by the rapidly increasing climate crisis, which only makes matters worse in terms of environmental degradation, but also the effects on people. So for all of these reasons, enhancing respect for international legal frameworks that are precisely there to protect the environment in war remains really critical. And we have, of course, heard about the wider environmental protection framework and the UN International Law Commission's recently adopted draft principles, which, of course, are a historic contribution to the clarification and strengthening of the normative framework on this topic. So what I really want to focus on is the international humanitarian law rules and the ICRC's guidelines on this topic, which, of course, as you all know, international humanitarian law is all about influencing the behavior of parties to armed conflicts, in this case, so that they take the environment into account as they fight, mindful of their obligations, but to be protective on the ground. And we've also heard that in the different remarks in the room today. They, of course, these obligations need to find their way into domestic frameworks and practices to actually be effective. And so I'm very interested and keen to hear some of the remarks later. So what are the ICRC guidelines? What you see on the screen, it's essentially what the ICRC has been focusing on now to respond to what I just said. The need to really take what we have in terms of existing legal frameworks and to bring them to the ground and to make it easier to implement them. So the 2020 guidelines are an update from the 1994 version. And what they do is they set out a set of 32 legal obligations as well as policy recommendations for states and parties to armed conflicts under humanitarian law. And they also provide a commentary to help in the understanding and application of these rules. So as I said, they focus on IHL, not on other bodies of law. And as we heard here, the ILC's draft principles, of course, draw from a wider body of law, including human rights and environmental law in particular, and also look at how they interact. The ILC draft principles also restate some of the core IHL rules and principles, and some of these and others are further set out in the ICRC's guidelines, which also precisely aim to provide more detail on these IHL rules. So this really just shows the complementarity with the ILC's work and the ICRC's guidelines. And as was mentioned, the aim of the ICRC guidelines is really to act as a reference, as a hopefully resource tool to facilitate the adoption of concrete measures on the implementation of IHL at the national level. So very quickly, you see what the guidelines, the content of the guidelines on the screen. It's essentially four large categories of IHL rules. The first are those that specifically protect the natural environment. So the additional Protocol 1 rules were mentioned earlier this morning. The widespread long-term and severe damage rule, that is. And here, for instance, the guidelines, and I should say the ILC's draft principles commentaries also highlight this, mention that although this is a high threshold, it has to be interpreted in line with current knowledge of environmental harm. And as I said, the guidelines give further detail on how to interpret this threshold. A second set of rules are those that provide general protection to the environment without that being their specific purpose. And they're really to highlight the rules on the conduct of hostilities, for instance. Then we have rules on weapons, and then on sort of the implementation and dissemination of IHL. So I already referred to the civilian, the conduct of hostilities rules. I mentioned them here in a bit more detail because it is one of the key sources of IHL's protection for the natural environment, but they are also some of the rules that are often overlooked or underapplied when it comes to the natural environment, which, of course, is civilian in nature. So lands, forests, water sources are civilian in nature, and as such benefit from protection under the IHL conduct of hostilities rules. For instance, attacking the environment, unless it is a military objective, is prohibited, as is disproportionate environmental damage. And perhaps as an example of how this can be applied to the natural environment, the basic rule of proportionality requires that incidental harm to civilian objects, including the natural environment, is taken into account. And this it refers really to what is reasonably foreseeable. So it doesn't relate to information that, we can't know a given effect. It's really about the reasonably foreseeable effects, but based on an assessment of the information that is available at the moment. And what I think is relevant there, and also hearing some of the previous speakers, is that, of course, this includes past data and past practice, but it also includes all the new knowledge that is increasingly growing on the effects on the environment of armed conflicts, including the long-term risks to ecosystems. But of course, it really will depend on the facts of the case and what is reasonably foreseeable at that time. Just to close, on some of our key asks, which are really about what I said from the start, right? So it's really about improving the protection in military practice, bringing some of this down to the national level. And here we see 4 key areas that we think could be worked on, and that we would be very keen to hear also views on. The first is really promoting and integrating the guidelines in national frameworks. So for instance, is the protection of the environment under IHL expressly incorporated in military education and training? Is it included in military doctrines, in targeting policies? The second area is really increasing the understanding of the consequences of war and assessing the impacts before a military operation. So for instance, could military personnel involved in planning seek advice from civilian agencies with environmental and scientific knowledge? And of course, this can be supplemented then by remote and open source data to assess if a given attack could cause prohibited damage to the environment. Can governments consider, or do they consider, environmental impacts when they review the lawfulness of new weapons? Do they conduct post-strike battle damage assessments that include environmental damage? And how do they learn from these post-strike battle damage assessments to inform what they do later? Third, and I won't go into more detail there because it's really what I talked about earlier, it's the identification and designation of protected zones. So have states identified sites of major environmental importance? Could they be placed off limits to military activities? And lastly, exchanging examples and good practices of measures that could be taken to comply with international humanitarian law's protections of the environment through conferences. I've already mentioned military training, exercises. And this is really about all states, not just a few. We see quite a broad range of practice here. Some have very developed practice in terms of dealing with environmental damage and how to look at it in targeting. But it has to, of course, be implemented more widely across all states and known by all states. And with this in mind, the ICRC, together with Switzerland, will be convening a state expert meeting on the protection of the environment in IHL in early 2023. So for all states parties to the Geneva Conventions. And it's really about what we've been talking about, sharing challenges, sharing practice on how to better protect the environment in armed conflict at the national level. So I'll leave those ideas and examples of good practices perhaps to feed also into the discussions. We know that the law is violated far too often, but we also know that this doesn't mean it doesn't influence behaviors and that it shouldn't continue to be used to try to influence them even more. So that's really just to say that the environmental protection component of IHL has to be more understood and has to become more of a reflex, and we would be keen to explore how we can do that and what practices are out there. Thank you.
Thank you very much, Helen. great presentation and on time. And the second will be Santiago Ripoll. Please, the floor is yours, Santiago.
Okay, thank you very much. First of all, let me thank the organizers of this important workshop for the kind invitation they've made me to participate in today's discussion. In order to answer the question organizers have posed me, the government's role, the Spanish perspective, I'd like to come back to something that has been tackled this morning. The task of the International Law Commission and these important draft principles on the protection of environment in relation to armed conflicts. No? And then I think that if we take a look on the position adopted by several states towards this draft principles, will realize of the difficulties states will have in the implementation of these principles. No? So I'll try to trace a general overview of the feedback from states to these draft principles. No? So in my presentation, I will consider the following ideas. No? First, I'll say that generally speaking, the draft principles in relation to the protection of the environment, in relation to armed conflicts, has received a positive reception by the states. Some delegations welcomed enthusiastically assented to consent of the draft principles. No? This is the case, for instance, of Greece, Croatia, Slovakia, no? Whose delegate said, the Commission's draft principles on this topic provides valuable guidance to states and other actors. No? Armed conflicts always have negative impacts on the environment and natural resources, and such impacts are often long-lasting and sometimes irreparable. Further, the draft principles offer a comprehensive systematization of rules applicable in this area. Together to these states, some other delegations, although not supporting the draft principles with all its terms, no? Some of the delegations expressed their support of the task of the ILC, highlighting specific issues. For instance, the inclusion of states, international organizations, and other actors in the protection of the environment. This was underlined by several delegations, but especially by the representative of the European Union in its capacity as observers, but also Vietnam, Austria, Estonia, South Africa, Portugal. In similar terms, some states like Japan, Nigeria, Romania welcomed the opportunity of the draft principles. No? New Zealand, for instance, said that the identification of such norms and the legal consequences resulting therefrom are of paramount importance to the international rule-based system. This is, she added, the delegate of New Zealand, this is particularly demonstrated by the Russian Federation's ongoing war in Ukraine, which violates the peremptory norms prohibiting aggression. So things that have had a special reception, a positive reception by states are the inclusion of states, international organizations, and other actors in the protection of the environment, the opportunity of the draft principle, and some of the points that received the support by the states were the inclusion of protected zones established by agreement, the reference to indigenous peoples and displaced persons, and particularly the consideration of the responsibility of an occupying power for the environment, to the environment in principle, this including Principle 11. No? In this sense, it was stated that occupation of a state's territory normally renders it unable to exercise its sovereign rights or fulfill its obligations to protect the environment. Therefore, imposing these obligations on an occupying party exercising de facto control over a territory is the only possible justified legal means of action. Let's move on now to the second point of my intervention, points of criticism and debate. Our first point of debate, of criticism, was the propriety of the temporal scope of the Commission's draft principle. Whereas the Federated States of Micronesia and South Africa, for instance, welcomed the draft principle's enhanced protection of the environment during and after armed conflicts, as environmental impacts occur before the start of armed conflicts through the testing and disposal of weapons, whereas some states welcomed this temporal scope of the Commission's draft, some others, such as Cameroon, pointed out that situations occurring either before or after conflict cannot fall with the category of armed conflict. Rather, they are governed by the existing regime of international environmental law. And then I'd like to point out the position of Palestine. Palestine considered that the draft principles do not always directly address modern challenges, including prolonged occupations and the exploitation of natural resources as tool of warfare and oppression. Much more important is, in my view, a second point of criticism and debate, namely the lack of distinction between international and non-international armed conflict. Such lack of distinction, stressed the Canadian delegate, for instance, detracts from the overall coherence of the draft principles. China also expressed its concern over the draft principles' application to international and national armed conflicts. Both differ vastly in terms of their nature, the parties involved, and the degree of harm. Then the Chinese delegate questioned the application of Principle 13 on non-international armed conflicts as a way of example. And this was a point also mentioned by Australia. Australia's delegate emphasized that there are substantive differences under international humanitarian law between obligations related to international conflicts and those related to non-international conflict. And he added that the draft principles do not currently provide differentiations. There is finally a last point where differences between the states were clear. It has been said that some delegations consider that the draft principles offer a comprehensive systematization of rules applicable in this area. These delegations welcomed the cross-cutting nature of the draft principles, as they draw from various fields, including international law, international human rights law, and environmental law. However, delegations expressing their concern on this issue were not numerous, but some delegations expressed their concern on this. Israel's representative noted that the draft principles conflate the rules of international humanitarian law, international human rights law, and international environmental law in a way that alters or misrepresents the substance of the scope of such rules. And he said these legal fields are each designed for a specific purpose and therefore should be understood as distinguishable from one another. And the US delegation, recalling that international humanitarian law is treated as lex specialis, pointed out a number of principles that conflict with this law by suggesting prioritization of environment over humanitarian law. Now, let me consider the position of states on the nature, mandatory or not, of the draft principles or of specific principles. In doing this, we should start considering language of the draft principles. Canada expressed its regret over the use of mandatory verbs in several draft principles to create new norms or extend well-settled rules. Brazil emphasized that such verbs should only be reserved for draft principles constituting lex data. Well, these interventions draw the debate to the nature, binding or not, of the draft principle or some of its principles. And a high number of delegations from states belonging to different regional areas and different legal cultures agreed the draft principle has not binding nature. Finally, let me talk briefly about the Spanish position towards the draft principles. Spain understands that one of the draft principles' aims is to integrate norms from existing armed conflicts law with international norms from other sectors, including human rights and environmental law. However, the draft texts do not always clarify whether a specific principle is mandatory in nature. Spain stressed that the commentary to the draft principles note that the principles applicable during military conflicts represents lex specialis, and while there is a discrepancy, it ranks above the norm of other sectors. And finally, in Spain's understanding, the draft principles do not always make clear whether a specific principle is mandatory in nature or rather a non-binding recommendation. So these are the main points that were exposed by states towards the draft principle, but in general terms, as I have already said, the principles, the draft principles, the task carried out by the International Law Commission, and here we have the special rapporteur, was very welcomed by the delegations. Thank you very much.
Thank you very much, Santiago. We have the third speaker. Please, Lázaro.
Good afternoon, everyone. And first of all, I would like also to thank the organizers, ICEL and University Carlos III for having the Ministry of Defense present in this terrific workshop. And personally, I feel humbled being part of this panel. Spain does not have any specific instrument within its national legal system on the protection of the environment in the event of an armed conflict. Although such protection is clearly contemplated in various regulations of the Ministry of Defense, showing the firm commitment of the department to execute its military activities and operations in a way that respects the conservation of the environment. In particular, with regard to NATO operations, the Secretary of State for Defense Instruction 56, dated 2011, directs the Spanish Armed Forces to comply with the recommendation of various NATO documents ratified by Spain, committing to take all reasonably feasible measures to protect the environment and ensuring that environmental planning is integrated into the planning process of military activities. Foremost among the well-developed NATO environmental protection documentation is the one of the military committee number 469, called NATO Military Principles and Policies for Environmental Protection, dated October 2011. This document defines the responsibilities of NATO commanders of units from all participating NATO nations, and non-NATO troop contributing nations for environmental protection during the preparation for and execution of military activities, and establishes, among others, the following basic principles: respect for the host nation's environmental laws, responsibility, understood in a dual sense. When conducting military activities, NATO and the participating nations have a collective responsibility for the protection of the environment. However, each nation bears ultimate responsibility for the action of its own forces. And third, I would like to highlight also the principle of transparency. The designated NATO commander will ensure that the host nation and affected community are informed of environmental damage caused and remediation measures taken by NATO forces, as long as the provision of this information does not negatively impact on operational imperatives and objectives. This document states also that the environmental protection will be integrated in all NATO military activities, consistent, of course, with operational imperatives, which will always have, at the end, priority over the environmental ones. That's an important point. The intent of the policy is to ensure that adverse environmental impacts are minimized. Effective environmental protection also enhances mission success by contributing to force protection, supporting operations primacy, and upholding the mission and commander's direction. It supports NATO's reputation and protects NATO from current and future environmental legal actions. Another key NATO document that I would like also to bring to the table is the Allied Joint Environmental Protection Publication number 3, titled Environmental Management System in NATO Military Activities. This document states that an environmental management system, EMS, should be implemented as the systematic management approach that enables NATO commanders to improve environmental performance, achieve established environmental objectives, and monitor conformity during a NATO military activity. This includes identifying environmental aspects pertaining to the mission and reducing adverse environmental impacts on military activities. NATO commanders will be supported by environmental protection officers to lead or coordinate all aspects of these environmental management systems and to identify potential environmental impacts as early as possible in the planning process, ensuring the effective development of mitigation and control measures. The minimum environmental protection standard that is foreseen is to hand back areas used by NATO in no worse environmental condition that they were received when the force is deployed. To achieve this, commanders must know how NATO military activities affect and are affected by the environment. Moving to the European Union level, the document EU Military Concept for Environmental Protection and Energy Optimization of EU-led Military Operations and Missions, dated September 2012, establishes that during military operations, the appropriate and proportional use of force to fulfill the military mission while avoiding or minimizing collateral damage is of utmost importance for the overall military success and for the eventual transition of responsibility to local authorities. The impact of military action on civil population, on its cultural property, and on the environment needs to be limited to the largest possible extent in order to comply with international law, to maintain the public support in the region as well as back at home, and in the longer term, to enable successful reconstruction and development efforts. Damage to the environment in an area of operations, especially when accompanied by natural resources scarcity, can lead to instability and result in new conflicts, whereas the preservation and protection of the environment during a military operation can foster lasting security and development. Therefore, environmental protection factors need to be taken into account during the planning and conduct of EU-led operations. Furthermore, this document outlines 16 principles that should be applied as much as possible to ensure coherence and maintain the EU's credibility in environmental affairs. However, due to the nature of military action, constraints might arise when domestic laws and rules come into conflict with military needs. In this regard, the first and most important principle is military necessity. The use of military force to the extent that it is necessary and proportionate to achieve a defined military objective, and in accordance with applicable rules of engagement, or self-defense may justify overriding environmental protection where this is necessary to ensure overall success of the operation. Other principles that I would like also to highlight are preventive action to address environmental protection from the first stage of the operation, polluter pays, I think it's self-explainable, energy efficiency, collective responsibility, and early planning. Moreover, the recently approved EU Strategic Compass states that by 2025, all common security and defense policy missions and operations will have an environmental advisor and will report on their environmental footprint. The Spanish armed forces have therefore the obligation and responsibility to carry out their military activities and operations in a manner that respects the conservation of the environment. While meeting their military mission, operational commanders should be committed to taking all reasonably achievable measures to protect the environment. To achieve this, commanders must know how military activities affect and are affected by the environment. However, during combat operations, environmental considerations shall be subordinate to the fulfillment of the mission and the preservation of human life, yet without implying that they can be ignored. In this regard, the Operations Command of the Spanish Defense General Staff has recently issued a standard operational procedure on environmental protection, the first of its kind, that rules the planning and execution of operation in this matter, either in a strictly national scope, where the Spanish legislation and regulations on environmental protection, or ratified by Spain, will be applied, or if they do so in the framework of international security and defense organizations or alliances, where the legislation agreed in each case will be followed, always ensuring the greatest possible protection for the environment. And I leave it here, open for questions.
Thank you very much, Lázaro. Okay. Thank you very much, the three speakers. Thank you for being accomplish the objectives of the environmental of this panel. And we have already, yes, more or less 14 minutes for question and answer period. Okay? Less? 10 minutes? Okay, we are going to run because we are 1 hour late. Okay, 10 minutes, please. Yes, Michael.
Okay. Thank you very much for the interesting panel. Can I be really cheeky and ask 2 questions? One for Mr. Rapoli. Talked quite a lot about the different state positions, and it's interesting watching those positions develop over the years and the level of engagement that different states had with the process. Spain's submissions, particularly over the last few years, have been very progressive and very positive. So I just wanted to ask you how you saw Spain's position now that the principles are about to be adopted, and what Spain's role was in future in promoting the universalization and dissemination of the ILC principles. And then a question for the Colonel. We've recently done a comparative analysis of military environmental reporting across the EU, and it was quite interesting to look at how different states are doing on that. With regard to kind of transparency and transparency of environmental information, what steps is Spain currently taking to report to the public in peacetime about its environmental performance? So, for example, on greenhouse gas emissions or on water or waste or other issues.
Thank you very much. Santiago, please.
Okay, thank you very much for your question, a really interesting question. I think that Spain is, as I have tried to expose, has welcomed the draft principles, and it's very compromised with environmental law and the dissemination of the principles not only the principles included in the draft principle document, but also the main principles of environmental law. So I think that the Spanish government will try to promote universalization of these principles in all the fora, no? In all the forums where it is possible. I cannot concrete any action, but I want to express, no, the commitment of the Spanish government with these principles. Thank you.
Thank you, Santiago. Please, Lázaro, second question.
Well, I can speak obviously for the Ministry of Defense, and one of the 4 line of efforts in the environmental policy of the Ministry of Defense is communication, dissemination, and cooperation. And within this line, we try to make our best to communicate our efforts, not only within the Ministry of Defense enterprise, with other departments of the Spanish administration, with the rest of the society, and also in international forums, mainly at the NATO and EU levels. It's a hard task because I mean it's clear that there is a prejudice that the military are basically polluters, and it's difficult to change that basic idea. But we are working step by step, and we try to, especially at the national level, to be present in all the different environmental or sustainability forums or congresses that are conducted. For example, there is for the last 4 years, there is a new defense industry fair. FAINDEF is the name organized, and obviously the Ministry of Defense has a presence there, a big presence, and the environmental affairs or issues are part of the contribution of the ministry to that fair. So basically, this is what we do at the EU level. There is currently a great effort specifically related to climate change. And for the, next year, when Spain will have the rotating presidency of the EU in the second semester, it will be necessary that every country will present a climate change strategy in the defense sector. So we have already started to work on that issue, and Spain will promote or impulse that effort at the EU level.
Okay, thank you very much. Very interesting news. Okay, we have to close this interesting panel due to the pressure of the time. But well, thank you very much, everybody.
And we are going to enter now to the 6th panel, which is the rapporteurship of the workshop conclusions. I thank the organizers for inviting me to moderate this panel of this interesting event. My name is Felipe González Morales. I am the UN Special Rapporteur on the Human Rights of Migrants, and the whole issue of the relationship between the environment and human mobility has been addressed by my mandate on several occasions, including in a recent report presented to the General Assembly of the United Nations last month on the impact of climate change on the human rights of migrants. So for this panel, we will have first online Daniela Dam de Jong, who is the Deputy Chair of the IUCN WCEL Specialist Group on Environmental Security and Conflict, Associate Professor at Grotius Center for International Legal Studies at Leiden University in the Netherlands, who will present the conclusions on the ILC's draft principles and its implications. Then we will have Laura Movilla, who is a PhD lecturer on public international law at the University of Vigo in Spain, and a research fellow at ICEL International Secretariat, who will speak about the need to strengthen international law on this topic. Third, Justo Corti and Álvaro Jarillo, who is Associate Professor and PhD Lecturer in International Law at the UNED in Spain, who will speak about the need for states, IGOs, and governmental agencies to take specific measures. And finally, who will speak online, Victor Tafur, who is the Deputy Executive President of ICEL and ICEL representative before the UN, Adjunct Professor at Pace University in New York, who will speak on the need for non-state actors, NGOs, and civil society at large to take specific measures. So we will start with Daniela Dam de Jong, who will speak online. Daniela, you have the floor.
Thank you so much. And let me first say a big thank you to the organizers for an amazing conference. I've greatly enjoyed all the presentations throughout the day. And I'm so sorry not to be with you in Madrid today. And also for missing out on Dog's birthday party. Dog, in any case, congratulations. And we'll see each other at another moment. So I've been asked to report on the ILC principles and their implications. And such an appraisal should, of course, start with an overview of their contributions. So let's start with a general observation. The ILC principles provide rules and guidelines for states and non-state actors in the most difficult circumstances, namely armed conflicts. Manuel Blas Gomez already reminded us this morning that in these situations, environmental considerations are subordinate to military and humanitarian considerations. This is a commonly held view, and I agree with it to a certain extent. Yet, I think this view does not fully take into consideration the interconnectedness between human and environmental considerations. The ILC principles demonstrate that environmental protection and human well-being are in fact intrinsically connected. For instance, by referring to the effects of environmental harm on human health. One only needs to think of the effects of the lighting of oil wells as happened in Kuwait in the 1990s and in Syria in the past decade to understand this intrinsic connection. Another example would be the armed conflict in Ukraine. The conduct of hostilities around the nuclear facilities are a threat to both the environment and human beings. Furthermore, I think the ILC principles recognize the battlefield realities very well and provide an appropriate and realistic balancing exercise between military necessity and environmental protection, where the aim is to strive for the best possible protection of the environment in the most difficult circumstances. In terms of the contributions of the principles, I can only echo Maria Leto, who touched upon key aspects in her presentation, namely the temporal approach taken by the principles, which covers the entire conflict life cycle and recognizes, in the words of Ambassador Leto, that preventive measures are most effective if taken before conflict breaks out. Second, the updating of the law of occupation, and that the principles set out special rules for occupying powers, which take into consideration the evolution of the law over time. Third, their interactive approach, which was also discussed by Concepcion Escobar in her presentation, and the fact that international environmental law and human rights law co-apply, and the principles expressly engage with that. Fourth, the fact that no general distinction is made between international and non-international armed conflicts, although we have just heard that this is also something that states do not all accept, given the diversities and the evolution of these two regimes. And fifth, the recognition of various causes of harm to the environment, not only hostilities, but also illegal exploitation of natural resources and, if I may add, human displacement. Other important contributions of the principles relate, in my view, to the consideration of corporate responsibility and liability, the sustainability of military operations, the protection of indigenous lands and protected zones, the recognition that the war crime of pillage applies to the illegal exploitation of natural resources, and the inclusion of forward-looking principles on post-conflict remediation measures. Another innovative feature of the ILC principles is the inclusion of the Martens Clause, as discussed by Montserrat Abad-Castellos in her presentation. So that's in terms of contributions. Now moving on to my second key point, and that relates to legal form. Of course, I mean, the ILC principles are, as it says, principles, and this may pose issues in terms of implementation, prompting the question of whether there is a need for codification of the principles in a binding document, as raised by Donald Caniaro. At the same time, I feel it's important to distinguish between the various principles, and more specifically between those that set out existing customary international law and those that are considered best practices and therefore represent progressive development. Many of the principles to be recognized by the use of shall reflect already existing obligations under international law. The need to codify these principles in a new legally binding document is strictly speaking not necessary, and also until risk that states negotiating such an instrument will dilute the language or enter reservations against rules that already apply to them. This may be different for the principles that reflect progressive development, such as Principle 4 on the designation of protected zones, which was discussed by Karen Hume and Helen Oberdon-Gieseken. I think it is also clear from their presentation that the regime for protected zones need to be further developed, whether this is through a separate agreement or within existing multilateral environmental agreements. The ILC principles have, very importantly, laid the groundwork for further legal development in this field. Indirectly related to their legal form is a point that was raised by José Justo Ruiz in his presentation, and which relates to a specific issue in the formulation of the principles, namely that the references to the applicable law in the principles may come across as circular. Of course, as emphasized by Maria Leto, the use of these references is partly strategic, and moreover, clarification is provided in the commentaries. Nevertheless, one may argue that the ambiguity that is inherent in the notion applicable law may pose problems for the implementation of the principles. This is not, however, a problem that is unique to the principles, and one may also raise the counter-argument that these general references to the applicable law enhance flexibility, ensure that states who have taken on more stringent obligations under relevant treaties cannot cast them aside, and enable progressive development of the law, as in these references take into consideration that the applicable law may change over time. So, this brings us back to the main question. What are the implications of the ILC principles for practice on the ground, so to say? I feel it's of critical importance that we now have a set of principles that comprehensively set out what rules govern the protection of the environment in relation to armed conflicts, and that these principles, through the temporal approach and by not distinguishing between international and non-international armed conflicts, have a broad scope of application. I think it is furthermore critical to emphasize that these principles are the result of a thorough study undertaken by the two amazing special rapporteurs and based on a broad consultative process. Maria Jacobsen and Maria Leto have both done considerable outreach involving international organizations, civil society and academics, but also very importantly, states were involved throughout the process. While one may argue that this is natural for the work of the ILC, it should also be emphasized that not every ILC study engages to the same extent with states' views. Because of this broad consultative process, I am confident that relevant stakeholders are also ready to implement the principles. However, it is equally important to sustain attention to the principles, and this is an important responsibility for everyone involved in the consultative process. Thank you very much.
A lot has been said about this topic I'm being asked to report about, on the need to strengthen international law on the protection of the environment in times of armed conflict. Beyond the obvious need to consolidate and operationalize the ILC draft articles on this topic that has already been pointed out by the previous rapporteur, I think the next points I'm going to expose now summarize the main legal issues, questions, and debates that have been addressed in this regard. I'm going to try to be quite brief. I know that we are behind the schedule, and I'm also going to try to not overlap with the possible conclusions of other rapporteurs, although I'm afraid that some reiterations are going to be unavoidable. So, first, it has been highlighted, of course, the need to strengthen the normative interaction among international environmental law, the law applicable to armed conflicts, and international human rights law, including the rights of indigenous people, but also the law of international responsibility and liability of private enterprises, or international criminal law. And this is clearly a call for further exploration of all the potential of the principle of harmonization and systemic integration when interpreting the international applicable law to, in harmony with a coherent and multidimensional international law system. Of course, the need to reinforce in particular the links between international environmental law and its general principles and the law applicable to armed conflicts has been especially highlighted. On the one hand, in order to reflect the increasingly present environment, peace and security nexus, and on the other hand, also to remember that international environmental law continues being applicable in times of armed conflict, as reflected, for instance, by the disposition of the ILC principles regarding the general obligations of occupying powers, as we have seen today with the example of the need to foster the extraterritorial application of climate change law in situations of occupation. Besides, it has also been pointed out that the application of international environmental law in this context helps to build up resilience of the environment in case a conflict breaks out, and provides both pre- and post-conflict obligations that can be useful, for instance, also as has been explored today in relation to protected areas. Other relevant points that have been raised are the need to reinforce, in particular, preventive measures, that international law should move from a localist and selfish vision of the protection of the environment towards a vision of it as a common objective of all the international community, as reflected in these ILC draft articles. Also, the need to clarify what constitutes existing customary law and what is progressive development in this field, or maybe emerging customary law, but at the same time also to explore the potential of political and soft law approaches, and also the usefulness of guidelines as those of the International Committee of the Red Cross, and also their complementarity with the ILC principles. Also, the need to explore still all the potential of the application of the Martens and Amman clauses in the protection of the environment in this context. The need to overcome the current mainly humanitarian framing of the problem of the remnants of war, and to address also toxic remnants of war that may cause damage to the environment at land and sea, as we have seen that the ILC principles do. The need to make environmental crimes more central to the transitional justice debate and practice, and also the need to see how to combine this protection of the environment in times of armed conflict with the basic and overarching ICEL principle of military necessity. Just as a main conclusion, I think that maybe the title of this part of the wrap-up itself, the need to strengthen international law on this topic, and of course its practical implementation, could be the overall conclusion of this workshop. We have seen today that the routes to consolidate this needed evolution of international law are there, especially now that we have this this wonderful work of the ILC finished on these principles. So let's hope that they germinate into effective application in practice, both before, during, after armed conflicts. Okay.
Thank you, Laura. And now on the need for states, IGOs, and governmental agencies to take specific measures about the topic of this event, the presentations by Justo Corti and Álvaro Jarillo.
Thank you. Thank you. I will start with the part from the international organization, and my colleague Justo Corti will continue with the states. Well, first of all, let me thank for the invitation and congratulations for all the excellent organization. In my case, I will be very brief to summarize, as my colleague made before, some of the references that have been made to the international organization. It has been clear that during this seminar, a lot of attention has been given to the states, which is logical, but there have been, even if there are not so many explicit references to the role of international organization, we can find some implicit reference to some of the concepts that are behind the ILC draft principles. Starting with the opening session, at the beginning of the session, they underlined already the necessity of retrieving the consensus inside the UN Security Council when dealing with armed conflicts and, of course, other issues regarding environmental threats and harms that we have been discussing. Afterwards, on the different comments about the interaction between humanitarian law, human rights, and environmental law, it was as well implicitly included the role of the international organizations, like shows the different mentions made to the ICRC guidelines and other instruments like the UN environmental programs and so on. As well, from a legal point of view, it was mentioned, it has been said already, the eventual extraterritorial application of the UN climate change regime. In this sense, our special rapporteur said that it was necessary to go beyond the law of armed conflict together with environmental law and human rights law, what is almost a call for action for the international organizations involved. Regarding the EU, it was emphasized more clearly and expressly the need for an integrated policy dealing with security, climate change, and economic change. In that sense, all of it's being developed already under the framework of the Green Deal and in line with the importance given to the cooperation with other international and regional organizations, as it was explained. On the military side, there were several mentions to the new NATO strategic concept, which incorporated already the environmental dimension and the climate change into the security strategy. In this regard, new elements have been included into the NATO system. When dealing with environmental protection, it was mentioned the collective responsibility and other strategies aimed to minimize the environmental impact of these military activities. This perspective was explained that is in line with the EU military concept for environmental protection and other EU instruments. As it was said, these instruments have direct influence on the national strategies and operations from the planning to the conduct of operation. All of these summaries of ideas and concepts that has been mentioned made us think that all the reference that has been made to the opportunity of these ILC principles as a first step for future developments can be a call and an opportunity for international organizations not only to contribute to their development, but also to incorporate them into their work. That's it. Thank you.
Thank you very much. I would like also to thank two organizers, to the International Council of Environmental Law and to University Carlos III for the invitation, and of course to the main organizer, to the Professor Montserrat Abad for the invitation. Well, I will try to fit to the time that I was given. Basically, regarding states have a lot of work for being doing, especially because it is expected that this principle will be applied mainly by states. there are problems regarding the applicability that were mentioned. Basically, one of the main point of this principle, which is the multidimensional interactive methodological approach, is one of the most important things, but also it's one of the elements that could create problems during the application, the putting in practice of the principle. It was mentioned that many problems regarding definitions, legal scope, competent bodies, nature of principles, what is the applicable law, the jurisdictions and problems, and also the temporal scope. All these problems, of course, that could be solved, but anyway, there is a huge work by members of the international community and mainly by state to be done. Basically, this work can be done, of course, by reaching agreements, by international agreements. But, for example, one of the points that was mentioned that it could be much more easy to solve was the question of the identification of the protected areas zone. However, it was also mentioned other ways, of course, of getting solutions for these problems. One of them are political or soft law approaches. It was also mentioned, of course, the work into the international organizations and also the work with non-state actors. It was mentioned also the idea of the importance of the bottom-up approach. It was also mentioned the idea that states could have different point of view, and basically a non-Western point of view shall be taken into account. Basically, the states could achieve agreements not only by treaties but also by customs, and also it's very important the incorporation of the rules of these principles not only in the national legislation but also in the practice of states. One of the incorporations that could be much more easy, of course, is the recognition of rights for indigenous lands, for example. But also inside the state practice, it is necessary to fill many gaps in order to integrate, assess, and exchange good practices. Finally, I would like to mention the problems of finance and cost that are included in this principle, and the problem of responsibility and liability. Thank you very much.
Thank you, Álvaro and Justo. And the final presentation is going to be made online by Victor Tafur on the need for non-state actors, NGOs, and civil society at large to take specific measures on the matter of this event. Victor, you have the floor.
Well, thank you very much. Good afternoon. Buenas tardes. And it's, of course, I want to thank the organizers, Monse, Thomas, and all the team at University of Carlos III for inviting me to close this session that has been very interesting, very filled with detail and with profound elements that we can now draw into our conclusions. I'm joining you actually not from New York, but from a forest close in Pennsylvania, actually not far when had General Washington crossed and surprised the British Army on that Christmas Eve, known as Washington's Crossing. And also not far from an area where there are some stories where there were some oil tanks that were made for the Second World War in case of an invasion. I will not hold my hand on the fire, but just to point out how we are touched in our lives and history with conflict, and probably more important, to prevent conflict. So I'll just jump into my job here. And I do have to say first, in full disclosure, that I didn't wake up at 2 a.m. to join the session because I'm in Eastern Standard Time. However, I really want to thank the organizers because the presentation is already alive. It's already live, and during your lunchtime, I was able to watch most of your remarks. So I really want to thank them to use the technology in the best way possible. And you will be amazed that all the morning sessions are already alive and for use of anybody out there. So with that, I was able to look at most of the presentations, and I have some general remarks, some more specific remarks on the principles, and three general conclusions. So on the general remarks, with regards to non-state stakeholders, to use it broadly, I think the key element is the approach on the life cycle and the approach on prevention. I think that brings a new light and a new challenge for non-state actors. It was highlighted in principle in the first point made by Ambassador Leto. So that I think is relevant, and I will add one point as I come from Colombia, where through my life I've seen the various processes, and to point that it's not just one life cycle, it's many life cycles, and they continue. For example, as we sit right now, as we currently see, there are many areas, despite the transitional justice process that has been going on, that are still controlled by various non-state actors. And using now the tools and elements and the principles would really help to prevent or even to solidify avoiding increasing or exacerbating the problems that we already have. So moving then to some particular specific points, I will just mention that, of course, principles 13 and 14 is where international organizations, environmental groups, NGOs, civil society at large can really influence the process and be part of this giving light, giving some real tools for using those principles. And of course, during the conflict itself, the issue of protective zones. So protective zones really draws the point where civil society can draw not just the elements, but the know-how, the traditional knowledge, the bringing the local experts, doesn't have to be the experts on certain remediation, but just the knowledge of where the resources are, how the ecosystem functions, how do systems work, ecosystems work, and that knowledge will be key to insert precisely that preventive nature that we're talking about. Then I'll just jump through the principles that apply after armed conflict, and just the two of them. In the peace processes, it is relevant, really, of course, for have state actors come, but I think not just as victims, but to have this broad spectrum of knowledge and have the entire society be part of it. We are concerned that once you go through one cycle, the other one is next to spin around. And also the principles after, one of them that is very central is access to environmental information. Because plugging environmental information, the knowledge that exists or what the information that is being built will be essential for civil society and other non-state actors to fulfill their roles. That coupled with other elements, for example, now in South America with the Escazú agreement taking place and many countries already having very good laws on access to information, that really builds. That's where the tools are. Some of the tools were highlighted, for example, in connection with the protected zones, how to address that. Professor Coleman did an excellent job there. And also actually Daniela has given, and my predecessors in the panels have given broad remarks on how civil society can engage. So finalizing, I have three general conclusions. On the need of non-state actors, non-governmental organizations, civil society at large to take specific measures, I think that was broadly covered in this webinar. I think the second conclusion is that on the foundations on the connection, on the why things are needed and why they are supported on the elements. That was strongly discussed through the process of the development of the principles and has been highlighted here. And more important, I think this webinar has pointed on how to do and how can civil society get in the implementation, in application. And that, I think, is not just the most important aspect, but this webinar has given some elements. Again, the use of environmental impact studies, the use of environmental tools. I think that is the word where I will conclude, tools. This combination of international humanitarian law, human rights law, and environmental law building up, I think that's where civil society has an extra responsibility also, and also the opportunity to plug in. So with that, I wrap it up, and I thank you all to go to the conclusion of the seminar.
Thank you, Victor, for your presentation and also for having attended this workshop since 3 a.m. your time. We really appreciate it. Now we have some time for comments or questions that participants may have. If there are no, we can move to the final section with the closure of the workshop. Thank you very much.
Good afternoon. Hello, Professor Robinson. Hello, Judge Justice Antonio Benjamin. Do you hear me?
Hello, Teresa. We hear
Hola.
you. Hello.
So my name is Teresa Parejo. I used to be a law professor here, but not anymore, unfortunately. But I'm linked somehow to ICEL, and that's why I'm here today. I'm just going to introduce these two great men. So I'm going to be very brief because what we want is to hear them, not me. But even though their curriculum, it's very extensive. I'm going to try to at least show part of it. So Nicholas Robinson, Professor Robinson, I had the immense pleasure to meet Professor Robinson in the year 2017 when we were both collaborating, of course, not with the same responsibilities, of course, in the Global Pact for the Environment. That time allowed me to enjoy his immense knowledge as well as his generosity and humbleness. That really struck me, working at his side and learning from him. Professor Robinson is a lawyer, a policy maker, but above all, at least for my eyes, he's an academic, a university professor. He has been awarded several environmental prizes, all of them very important, like the Elizabeth Hub Prize in Environmental Law, the National Environmental Quality Award by the National Resources Council of America, or the honorary membership of the World Conservation Congress of International Union for the Conservation of Nature, among others. He's one of the founders of ICEL. He's currently executive president of ICEL and chair emeritus of the World Council of Environmental Law. He's everything in the environmental law. And on the other hand, Justice Antonio Benjamin, another huge figure in international environmental law, a tireless worker and great friend of Professor Robinson. I also had the honor of meeting him during the brief time I worked on the configuration of ICEL in the Madrid office, which is now led by great success by my friend Monse. You're leaving. Bye-bye. Monse Abad. He has served as justice of the... Okay. He has served as Justice of the National High Court of Brazil since the year 2006, when he was appointed by President Ignacio Lula da Silva. He's chair, well, now emeritus of the IUCN World Commission of Environmental Law, and Secretary General of the International Advisory Council of Environmental Justice for the United Nations Environmental Program. In addition to an intense career as a judge, he has led numerous institutions linked to the protection of the citizens' rights and also to the academic world. As such, Professor Benjamin was linked to several universities, both nationally and internationally. Well, both are major figures of the legal world. Their contribution to advancement of the legal protection of the environment is undisputed. But we are here to listen to them, so I'm just going to be quiet from now on. So please, the floor is yours. Professor Robinson?
I think Justice Benjamin is first.
Oh, okay.
Yeah.
Professor Robinson. Hi. Antonio Benjamin, please.
Yeah, you know, Teresa, can you
Hello.
hear me?
Yeah.
Can you hear me?
Sí. Sí, muy bien.
¿Sí?
Sí, perfecto.
Gracias. Buenas tardes. En primer lugar, quería agradecer las palabras muy generosas de Teresa Parejo, que es, como todos lo saben, muy querida y una profesional extremadamente dedicada. Y además ha sido fundamental en la creación del...
Perdón.
¿Me escucha?
Sí, perdón, ¿puede en inglés, por favor? Ya sé que esto no es problema
perdón.
para usted, sí.
Okay, so I'll
No hace
say
falta
the
que
same
hable de
thing.
mí, directamente al grano.
So I'll say in English what I was trying to say in Spanish. First of all, to thank Teresa Parejo for the very kind introduction. As you all know, she is not only one of the most competent people I know, but also one of the kindest and very generous with friends. And me and Professor Robinson are benefiting from this. It is a great pleasure as president of the Global Judicial Institute on Environment, but also as part of ICEL. So we here have not just different hats, but simultaneous hats to participate in the closing of this event that discuss a very relevant topic. It was relevant before, it's even more relevant nowadays, especially in light of the crisis that we are facing in different parts of the world. And as Teresa Parejo mentioned, this is an event that is organized mainly by Carlos Tercero and University and ICEL, but also with the collaboration of other institutions, including the World Commission on Environmental Law, the Global Judicial Institute on Environment, and our colleagues from the Normandy Chair for Peace. My first gratitude goes to Carlos Tercero University. It's so important to have this event hosted by the law school, because it gives not just substance, but also credibility to the debate that we are having. And we are very grateful to have so many students and law professors involved in this event under the leadership of our dear colleague and friend, Professor Montserrat Abad, who is leading us in not just within Carlos Tercero, but globally, bringing new topics that are not that close to our daily life as environmental law practitioners. From the judge's perspective, what I can say is that when we judges deal with environmental cases, we usually see people at war with the environment or against the environment. We don't put in those terms, but it's basically a conflict between people on one side and bad use of the natural resources and the role of law in trying to adjudicate that situation. It is already very complicated because we judges cannot really grasp the full dimension of the environmental crisis, and especially judges that are not fully specialized. Well, the situation becomes even more complicated when we are dealing with a double conflict with simultaneous negative impacts on the environment. So a conflict of people against the environment, but also conflicts among people, armed conflicts in this case, that either directly or indirectly harm the environment. Therefore, the topic of this event is very important from our perspective. First, because it illuminates an area that we judges are not familiar with, or at least the perspective, the lenses that we see in this event, armed conflicts. Second, because it shows us, the judges, that in countries like my own or Spain, the European Union with, but not far away, the situation is different, that we are very privileged, if I can say so, because we are dealing with the first type of conflict, people against the environment, but not people against people, and in this process, the environment being threatened or damaged. Of course, we cannot forget that sometimes those armed conflicts, as Victor Tafour alluded to, are not international in nature. They happen within a single country. And he didn't mention it directly, but implicitly was there, the situation in Colombia, but in many other parts of the world. So I would like just to thank the organizers on behalf of the Global Judicial Institute on the Environment. Professor Nicholas Robinson will do the same with ICEL, so I'm not going to say anything from ICEL perspective. And this is a conversation that will continue happening, not just within the walls of the International Law Commission, but also we have a duty to expand this discussion beyond those small circles that of experts that deal with this matter. This is an existential threat that we face. I know I'm using the same term that we do for climate change, but armed conflicts do touch or bring us to the worst of our history, precisely at the moment when we should be focusing on the other types of environmental threats, like the climate change crisis, the biodiversity crisis, the pollution crisis, and so on. So many thanks to the organizers, many thanks to the speakers, many thanks to the students that are there and helped in with the logistics, and many thanks to you, querida Teresa. Gracias.
Professor Robinson, the floor is yours.
Muchas gracias, Teresa. I'm very happy to be with you all virtually. I wish I were there in person. This has been such an outstanding workshop that I'm envious of all of you who could be in Madrid to participate in a live way. I want to also extend the thanks of the International Council of Environmental Law to the Universidad Carlos III de Madrid and all those who organized this wonderful workshop. It couldn't be more timely, as you know, the presentation of the draft principles by the International Law Commission to the General Assembly, the various humanitarian law initiatives that have had to be taken in light of the armed conflict in Ukraine, but also in other parts of the world experience armed conflict, ongoing conflicts in Burma and Myanmar, ongoing conflicts in parts of Africa. We can't forget that this is the global challenge we have to make humanitarian law and environmental law and human rights law become observed and effective. They're not just norms, but they're norms we have to live by, norms that our governments have to observe and advance. And this role of all of the international organizations and the organs of international organizations has become a fundamental principle. It's a ground norm. We cannot outsource it or delegate it to someone else. It's not just the question for the International Committee of the Red Cross. It is not just the question for the ILC or another organ of the UN. It is not just the question for the Commission on Environmental Law of the International Union for the Conservation of Nature. It's an obligation that all civil society and all branches of government, both regional, local, international, national, have to undertake. And it's obvious why. We see it in the war that goes on around the world. This places the Sustainable Development Goals, which Teresa and I and others work so hard to help the UN to understand and adopt. It places the Sustainable Development Goals at risk. It's quite clear we will not attain the Sustainable Development Goals in the time frame we want. It's partly, of course, the COVID-19 pandemic. It's partly the war in Ukraine. But more fundamentally, it is the failure of national governments to prioritize attaining the SDGs. So we're in a very unusual moment in time, which all jurists have to reflect upon. And this workshop has helped us do that. We are at a time in which humanitarian law and environmental law and human rights law are converging. They are part of the same body of law. We saw this when the ILC principles brought environmental law into that question of armed conflict. We see it in the way principles 14 and 15 of the Sustainable Development Goals prioritize the environment. And ultimately, in the decision last July by the United Nations General Assembly to embrace the human right to the environment as a fundamental human right. Indeed, it is the right on which all other rights are grounded. So this workshop has given us ample legal analysis for all of us, the jurists assembled here and the ones who will learn from this workshop, about the guidance that we must give to the international community and to society about how to move forward. Now, this guidance has to be practical. We can't simply reaffirm what we have before. It is, of course, ironic that the Martin Clause, which we celebrate and enhance with the Amman Clause, was originally presented by Professor Van Martens He was then Russia's delegate to the 1899 Hague Peace Conference. We have to resurrect that spirit in all countries and legal systems. But there are ways to take the fundamental humanitarian law norms, now merged with environmental norms and human rights norms, into an operational stage. And I take away from this workshop the priority that we must make these values operational. They must be put into practice. And here are some of the ways we have learned how to do that. After the International Court of Justice issued its decision on the use of nuclear weapons, indicating, of course, that it would be contrary to international law to ever use a nuclear weapon, many nations around the world created nuclear-free zones. They said, we're not going to have these weapons in our territory, our regions, and our national territory. And this has had a fantastic effect of limiting the spread of nuclear weapons and their use. We have this going on in the environment now. Many nations are declaring in their exclusive economic zones marine protected areas. Much of the South Pacific is like a nuclear-free zone, only it's an ecological zone. The marine protected areas cover much of the ocean now, and they are growing. And the movement for this extends on land also. Today, there are more than 300 peace parks around the world, indicating between adjacent nations, but also in other places, that these are ecological reserves for peace, to let nature and humans in nature thrive and keep military conflict or political conflict or economic conflict out of the peace parks. So we know how to designate territorial areas and take them off limits for violations of humanitarian and environmental law. We have also some very practical guidance. IUCN's Commission on Environmental Law consulted with the International Committee of the Red Cross on military manuals back in 1996. And a number of nations, of course, have military manuals to guide what their armed forces should do to observe humanitarian law. But we must now revise the military manuals around the world for this convergence of human rights law, environmental law, and humanitarian law. And we must extend the use of military manuals to all nations. The ones that choose not to do so and don't educate their armed forces about these legal norms are at fault. They are not helping international cooperation. There are many things, priorities they may have that they consider higher, but I think this is now one of the highest priorities. And finally, the UN Environment Program has published a book 2 years ago, a very good study entitled Making Peace with Nature. It is a synthesis report on the crisis of biodiversity loss, the crisis of climate change, and the crisis of chemical pollution and contamination. It describes not fictional accounts, but the actual degradation of the life support systems on our planet and how the degradations interact with each other. Well, the workshop today makes clear that the degradation of the environment is going to make it more likely that we have more armed conflict. And so we're going to have to help protect nature if we want to create peace with nature. And this message is incredibly important. The International Federation of Red Cross and Red Crescent Societies several years ago announced that they spend more time and effort and resources on helping civilians in environmental crises, in floods, in massive ecological disruptions from storms and so on. They spend more of their assets in that response than they do for responding to armed conflict. So the war on nature is something that the International Federation of Red Cross and Red Crescent Societies must respond to and is responding to. But they are the leaders. Where are the rest of us? We must also respond in the same way. So I want to urge us all, as we reflect on the outstanding papers and presentations, to add this dimension of operationalization. We need to educate the young about the importance of having zones in which we prioritize sustaining natural systems and zones in which armed conflict has no place. Without this, we will not have the resources we need to implement the Sustainable Development Goals. If we want any case study of what the difference makes, I give you Costa Rica. Costa Rica decided to abolish its army. Costa Rica decided to create peace parks, if you will, protected areas on its borders. And Costa Rica has diverted its financial and educational resources into public health and sustaining the environment. So we don't have to imagine how this would look. We have a case study that allows us to emulate the leadership of Costa Rica. I want to leave you with these thoughts that it is doable. Operationalization of the norms for a peaceful world have to be realized. The alternative is not viable. And if we want civilization to continue, this must be a theme that permeates all dimensions of our lives, commercial, non-commercial, educational, and so on. So I want to echo again the fine words of Justice Antonio Herman Benjamin, and thanks to all of you in Madrid. He is also the governing chairman of the governing board of ICEL, though there are many people wearing hats that are interchangeable here today. But that shows the convergence is happening. I look forward to the follow-up to this workshop and thank Montse and everyone who has had a leadership role in pulling it together. Bravo to all, and I wish you a fine weekend coming up. Adios.
Thank you. So, any questions? Monse, aquí cerramos o. Sí. So, thank you very much. Thank you, Professor Robinson. Thank you, Justice Antonio Benjamin, for being there and sharing all your thoughts with us. Have a lovely day. We're closing now. Thank you so much. Hope to see you soon. Bye-bye.
So thank you. Thank you to all of you. Well, it's Friday night.
We're young.
Right, we will talk now about the following steps.
Professor Robinson, perdón. I want to speak with you, Professor Robinson. I'll email you, okay?
Okay. Muy bien.